Everyone, it's a tiny bit irregular for me to be looking into a laptop, and probably should have got more used to this during COVID. But I understand that we've got a really substantial audience and we've got plenty of people in the room. And I want to start by saying what an honour it is to act as the chair with such an eminent panel. And I think you all know everybody we have. We have Lord Thomas, the former Lord Chief Justice, Nick Vinall, Chair of the Bar Council. We have the Attorney General, Victoria Prentice. I'm just assuming you can all see us, but if you can't, he's here. We have Andy Slaughter, who is the Shadow Solicitor General, and Logan Shah, who's the Chair of the who's the Chair of the Law Society, and then Lord Hunt, who President, and then Lord Hunt, who chairs this All-Party Parliamentary Group with me. So the title of this is quite wide. It's about the relationship between lawyers and the executive. And I just actually wanted to say, I came to Parliament, I arrived in 2019, and I've been a barrister for 12 years before that, principally practicing in employment law, but also with a public law. There was a public law aspect to my practice. And one of the things actually that makes me really pleased that I'm doing this with Victoria and with Andy, irrespective of their titles, is that even though there have historically been there are lots of people in Parliament who would say that they're a lawyer, but I think that one of the hallmarks about somebody who really takes the law seriously and takes that professional route really seriously is whether they sit on the Justice Select Committee in their parliamentary career. I don't know if you agree with that. If you disagree, if they would like to, but I sort of think it tends to be, a lot of it is, former practitioners who really want to look under the bonnet of the legal system and bring their experience in a useful way to the work of scrutinising the executive. And I really loved my time in that select committee. And I think the other thing I would say, which is consistent with that, is I've always felt a bit like a lawyer parliamentarian. I always think I'm sort of a lawyer first and an MP second. And I don't know if it needs saying, but I'll say it anyway. I have incredible respect for the profession through the bodies that, represent it. And it was such an incredibly formative time of my life, learning a degree of rigour and argument, how to present an argument, that I would always treasure, really starting from pupillage and going through my career. Even when, judges were giving me an absolute roasting, I learned something and I developed, and you do have amazing opportunities to develop. I thought my role is to chair, not to express views particularly today, but I thought I'd just perhaps throw out a few remarks that are not intended to be polemical, but they are, perhaps truths, or people can either agree or disagree or develop them, or just think they're not points that are worth making anyway. The first thing I would say is I think it is worth acknowledging that there have been moments, perhaps particularly since the Brexit vote actually, but not exclusively, where there has been a degree of tension between the legal profession and the executive. Yeah. I'm just going to sort of flag that. But I think there have been things, and I don't think any of us in this room or on this, who are part of this meeting today, would ever seek to suggest that the legal profession is beyond reproach. In fact, I don't think there's any sector or any area of, professional life that is beyond reproach. And I think there are a few things that have changed in the last 10 years, maybe some in the last 20 years. One of them is Twitter, actually. And that is when you get, I would be following barristers just because of the way my life is unfolded, but you can follow people who will have a professional specialism, but will express very strong political views on Twitter, which may actually not be directly relevant to what they practice in. And it does, in a way, establish who they want to be seen as. Their profile will make clear they're a barrister, they're chambers, and they will, in a way, they will be seeking to embed an identity. And that goes to the second point, which is, of course, you should never conflate the barrister or the lawyer with the views of the lawyer with the views of their client. But some lawyers, perhaps Twitter being the gateway, have almost sought to do that and have, certain types of cases they wouldn't ever take on. They wouldn't, perhaps in an asylum case, contemplate ever acting for the Home Office because they represent claimants, and that's something that defines when they might talk about that at the same time. I'm just throwing this out as issues you might wish to discuss. And I suppose the only other aspect of the profession, which I think has been engaged in a way that I never considered as a practitioner, but have considered as a parliamentarian, is not just the operation of law, but some areas of law where we've also had to consider the way that the legal profession has operated within it. And I'll give you two examples. One, I think, is slaps and some of the, way that it was operated, the way that certain lawyers behave. I think that's been quite controversial. And also going back to the practice area of my own, because I was in employment law, NDAs, and actually, first of all, I hate that expression because we don't really use it in domestic law, but confidentiality clauses in compromise agreements, which are completely typical in any employment settlement, but the way they've been used is sexual harassment, where the conduct, there is no admission of liability, but the conduct contended for is serious, perhaps somewhere close to the criminal threshold, and the extent of the confidentiality obligation has been extreme, at least very high profile cases of harassment, and the profession's conduct has been engaged in those sorts of issues. So that was just one other area. I think that's all I had to say as opening remarks. We've got an order, and I'll make sure I stick to it. The first speaker I'm delighted to welcome is my friend, the Attorney General, Victoria Pence.
Oh, well, thank you, Laura, and that was a characteristically open introduction. I must say it gives me great pleasure to be here with friends, and also perhaps as a special category of people who've served on the Justice and Select Committee, and also have chaired this APPG, in which category I put both of us. So it is genuinely lovely to be here. And I'm very lucky, I feel very lucky to be attorney at this time. And it's also great to be in a room with people who I know have thought about the rule of law, the independence of the judiciary, access to justice, the professions very deeply. And these are people I work with genuinely on a daily, if not weekly basis. Lord Hunt and I see each other a great deal, and he acts as a very important liaison point between the Lords and the Commons. And it's really integral to the way that legislation is passed. Lubna and Nick and I saw each other last night on the legal walk, which many people present will have been in. I thought that was really good fun. It's not just an opportunity for junior members of firms and chambers to go and have a drink in lots of pubs along the way, but that definitely happened. But it was also a chance to see the breadth of our legal profession, and what there were lots of firms, lots of chambers, lots of different types of judge, lots of people who work in the court services. I was very pleased to lead some GLD and GLP lawyers, and CPS were out in force. And it did just remind me, if I needed reminding, of the breadth of our profession and the work that we do. Andy and I have always enjoyed working together, not least on the great Justice Select Committee, and Lord Thomas, the great man, whose successor in office I see very regularly. Ian Burnett as Lord Chief at the moment, and we look forward, of course, to a new Lady Chief that will be announced very shortly, though we will miss Ian. Seeing him last night in a t-shirt did give me a bit of a jolt. That's not something, he was my pupil master a very long time ago, and I must say I've never seen him without a jacket on. But seriously, if I may for a minute, I think what I can probably bring to this discussion, apart from anything anybody wants to ask me about the role of attorney and the important leadership role, I think that the attorney does have as leader of the bar, but as also the voice of law around the cabinet table and in various ministries. I think that the special thing, if I may say, that I might bring to this discussion is my previous history as a government lawyer. So I joined the government legal service in 1997. It was very much at the early stages of judicial review. Judicial review grew exponentially from when I was Ian's pupil and Dominic Grieve's pupil in 1995 to where we are today. I feel very fortunate to have been there during those formative years for JR. And I do think, and it became clear in case law over the years, that government lawyers have duties above and beyond those of other lawyers. Obviously, we are subject to the same rules and regulations and professional obligations as everybody else, but we also have a duty of candour, and we also have an obligation to speak truth to power. It's our job. And I feel in my role as attorney that continues to be my obligation. I, like Laura, definitely self-identify as a lawyer before I'm a politician. And I think probably all of us do here, though I have to say those who lead their professions have definitely become politicians. And I think it is the role that I have as attorney round that cabinet table, talking to other ministers about complicated legal issues. And frankly, it's only the complicated ones that get to the attorney's desk. The rest are dealt with well before they reach me. Is to say it how it is, just as any lawyer does to their clients, but we really have to say it how it is and explain why. And I take that role extremely seriously indeed.
Thank you very much. Now, our next speaker is, sorry, Lord Thomas. Well, thank you very much.
First of all, can I say what a pleasure it is to join you, join everyone here. And I want to answer the question I've been given. I do the opposite of what I'm try and answer the question, but I want to answer it in the context which I've been given. And that is, what can the legal profession do to try and improve matters? And we've already had an example of the first thing, which is to behave and act as friends. One of the problems much modern litigation is people get into awful antagonism and don't realise that the primary role for a lawyer is actually to do things in a friendly spirit. Very tough, but friendly. And this is a wonderful group, and it shows how it actually can be done. The second, which has been touched on, are the very high standards to which lawyers ought to aspire. And I don't want to add to what Laura and Victoria have said, because I completely agree with them, that there are difficult judgments to make. People are always prepared to be extraordinarily cynical about lawyers for good reason. But I very much hope that, you know, we will have a return to ethical standards. And it is very, when I was asked on a similar subject, chair of discussion on a similar subject, if you look back at newspaper headlines, I'm afraid governments always had it in for the lawyers, just as people in general had it in for the lawyers. And I don't think it is very different under the Labour regime to the current regime, and people forget that. And thirdly, what can lawyers do? And I think one of the big problems that's facing the profession or the government at the moment is the need that people are equal before the law, because unless you're equal before the law is meaningless and people lose confidence. And when I was in the US last month, someone was explaining that there are approximately 200 million issues in the United States each year which give rise to legal questions between ordinary people. About 20 million of those cases end up in court, and only in 75% of those do you find that the person at the receiving end or bringing the claim is legally represented. And I think we face a similar problem. I can't give it statistically, but there is not enough legal advice available. And there are three solutions. One, put more money into legal aid. I believe that's a question for those who are more familiar with politics, but being realistic, the justice system is always in every country at the bottom end of the queue. Secondly, look for alternatives. For example, consigning more disputes to regulators for decision, expanding something like the financial ombudsman services, and actually bringing tribunals back to what was originally intended, i.e. for people's ordinary disputes, such as employment disputes over housing or employment, to a much simpler form of procedure where you can manage without lawyers. Maybe you ought to ensure that if both sides can't afford lawyers, then there shouldn't be a lawyer on either side. I know that may be something the profession would hate, but I do think we have to look at that. And the third, and what I think really is merited, is that the legal profession is itself now divided into two halves. Probably they're not halves, but into segments. And that reflects what is happening in society as a large. And if you have a lot of money, the access to first-rate legal advice is wonderful. But if you are not in that category, you're not. And I very much hope that the profession, and particularly the large firms, will do more to encourage their youngsters to help. Over 50 years ago, Chris Bellamy and I used to advise listening to the Legal Advice Centre. He was then a young and already eminent competition lawyer. I was sort of picking up the threads of commercial law. So you don't actually have to have a background in ordinary people's disputes, such as housing, which was landlord and tenant in particular, and employment, which were the great problems. And I do think that it's good for the firms, but more importantly, it's good for the lawyer to realise that actually they're coming to a profession whose duty is to try and help the law in general. And you ought to know about what matters to men and women in the street.
Thank you so much. I've just literally been dogged in constantly. I agree with every syllable. If I may say also, just going back, I think Andy and Victoria, I think all of us had a discussion, informally or otherwise, about the benefits of pro bono and how obviously it's not a substitute for legal aid, but an adjunct to it. And you know, whether there is a way of carrot and stick, but you know, really trying to get it, making it compulsory for every law firm because it is so important and it can be some of the most formative cases you'll ever work on. I'm very, very pleased to introduce our next speaker, Lunda Shuja, President of the Society.
Thank you very much, Laura. I'm absolutely delighted to be here and talk about something as important as the legal sector and the changing ethical landscape. I appreciate it's got a parliamentary audience, so I'm going to take this opportunity to touch on some of our ongoing concerns about how political discourse, which we've already alluded to earlier in the conversation, is making the landscape harder and not easier to navigate. We all know that where parties can't agree and where they have a legal dispute between them, they will often take their cases to a lawyer and they will often end up in a courtroom. Because parties want different outcomes, a legal decision will usually leave someone dissatisfied, or at least one or more party will not be completely happy with the outcome. That's just the nature of contentious proceedings in court. But people don't like to, they don't have to like the decisions that judges make. They do have to like, sorry, they do not have to like that everyone is entitled to a legal defence. Justice is not a popularity contest. The key thing is that they need to have respect for proper legal processes and for the independence of our legal system. Where a case involves the state, it will almost inevitably touch on questions of our constitution and in particular on the constraints on power. It is the lawyers and it is our courts who address the inherent inequality of arms when citizens challenge the power of the executive. All legal practitioners are bound by a strict code of conduct, and I know that our members always aim to meet the highest standards on behalf of their clients and as part of their duty to the court. We have very, very strict regulations in place to make sure that there is client confidence in their lawyer and public confidence in the legal system. The regulations are set in part by law and in part by our own sector regulators. So in the case of solicitors, we have the Solicitors Regulation Authority. That is largely how it has always been. The public are not involved in the day-to-day running of the legal system, but they trust that the institutions that govern it and they trust the system itself. But where the ethical issues come in is when our world is changing. We are finding more and more that public opinion and media narratives are influencing the way that we work and the way that we run our businesses. Solicitors are finding increasingly that they are having to grapple with environmental and social concerns. These issues are constantly evolving and public attitudes, as well as media rhetoric, are changing, sometimes in a matter of days, sometimes in a matter of weeks. Solicitors largely take this in our stride. It is absolutely right that we consider the environment that we're practicing in, and we consider whether our regulations are up to date. We want to remain a trusted profession by the public. We are here to serve the public. They don't have to like all of the individual decisions that we come to, but they should be able to respect the method and therefore the outcome, and that it is fair and it is independent. What has been worrying the Law Society for some time is when external factors threaten the trust that the public might have in the legal sector and in practitioners. Recently, we have become more concerned that the government is often overstepping the mark in commenting on the legal system in a way which undermines its independence. For example, we've heard several remarks being made about lefty lawyers and about activist lawyers. Certain attacks have been made specifically on human rights lawyers and immigration lawyers. In recent years, our members have been physically attacked following heated anti-lawyer rhetoric. There are real-world consequences from some of the remarks that have been made. Attacks on the integrity of the legal profession undermine the rule of law. It is misleading and dangerous for ministers to name court lawyers who are doing their job and upholding the rule of law. We should all be proud that we live in a country where legal rights cannot be overridden without due process, and that we have got legal professionals who serve the rule of law and they keep the government accountable. But more than that, the very function of good government is entirely reliant on lawyers. Government lawyers and law enforcers are integral to good government. I want to take this opportunity to gently remind the government of this. Undermining the independence of lawyers will also have consequences for the government as clients, as much as on any other lawyer and client relationship. So I just want to conclude by restating that lawyers are bound by strict codes of conduct and regulations that ensure ethical practice. We carefully monitor the changing ethical landscape. We routinely review our regulations to make sure that they are up to date and appropriate, whilst making sure that procedure is not changed simply to make the public like us more. It's a very delicate balance, but I think it's one that we do quite well. Thank you.
Thank you very much. And now over to the Chair of the Bar Council, Nick.
Thank you. Thank you, Laura. It's an absolute pleasure to be here, particularly amongst such distinguished company. I am going to take a risk. I am going to start with something which some people will think is really boring, but I think it's not boring and actually very important. I just want to tell you what the first 4 core duties are that barristers act under, because it frames much of the debate we have. So bear with me. Core duty 1, you must observe your duty to the court in the administration of justice. And of all our duties, there's only one that the code says is paramount and trumps the others, and it's that one. So our absolute primary duty is to the court in the administration of justice. That's really important. Core duty 2, you must act in the best interests of each client. Perhaps obvious. Core duty 3, you must act with honesty and with integrity. You'll notice there are no ifs and buts in that core duty. You must act with honesty and with integrity. And core duty 4, you must maintain your independence. Notice, no ifs and buts. You must maintain your independence. Now, there are another 6 core duties, but I know when I might be running out of luck and attention. But for present purposes, I think they are probably the most important 4. Perhaps I can jump on from that. But what is the role of a barrister? What is a barrister there to do? And I think that the role of barristers is in some ways quite constrained, quite limited. Within the confines and always subject to these very exacting duties, I think that our role is to advise our clients, and in the light of their instructions thereafter, to represent them, but nothing more. And I want to stress nothing more, because some people think that perhaps barristers should go a little further. And if the client wants to do something which is, quote, lawful but awful, whatever that means, whatever that means, they should perhaps engage some judgment as to whether or not to do it. I have to say, I think that's misconceived, because the role of judging is for judges and for juries. The clue, in a sense, is in the name. Judges and juries judge. We advise and represent. And I think if we keep hold of that analysis, quite a lot of the thorny problems, and there are thorny problems which come up, you can find a solution to. Now, at the bar, we are also subject to something called the cab rank rule. And the cab rank rule, again, the clue's in the name, at least if you understand how London cabs work, says that if you're a barrister and you're offered work which is properly remunerated and you're available to do, it's within your expertise, you must do it. You may not decline it on the basis of your opinion of the position of the client, reputation, or the opinions, or the cause of the client. Just not allowed to. And of course, it flows from that, and this is the point made by Laura already and by the attorney. That is why it is so important that lawyers, both barristers and solicitors, are not associated with the cause of their client merely by virtue of having represented. In the case of barristers, we don't have a choice. But in the case of any law, their duty is to do their best within those constraints for the client. And so it's quite wrong to associate lawyers with their clients merely because they represent them. They might say something which causes that protection to be lost. And Laura, I think you were hinting at this when you talked about what people say on Twitter. And people can, I think, overstep the mark and choose to associate with their clients. Well, if you do that, you can be called out, and that's fine. But unless and until people, lawyers do that, they shouldn't be associated with their clients. And that, if I may say so, why Laura is absolutely right to refer to some very unfortunate comments earlier in the year about lefty lawyers, and we both pulled them out and criticised the makers of those comments. And I think credit where credit is due. I have not heard it over the last 2 or 3 months. And so I think and I hope that message has got home. It's really important, but for those who might have been tempted to use those lazy tropes and are no longer doing so, well done. You're doing the right thing. And thank you. So that's all I wanted to say by way of introduction.
Thank you very much. And last but by no means least, Shadow Solicitor General Andy Simpson.
Thank you, Lauren. It's a real tribute to your reputation that you assemble such a distinguished panel, which I exclude myself from because I'm just 2 doors away from you in the same corridor. You get me to do things at short notice. I would say 3 or 4 quick points. First is about eligibility and access to legal advice and reputation. You might say, what's legal advice and representation? You might say, what's that got to do with a reputation? But I think it is very clearly linked. We've seen some perhaps rather tentative steps towards improving access, the loosening means test, the I was going to say the criminal legal aid review, but there's a sitting next to me, I'm not sure. Civil legal aid review seems to be going very slowly, but in the right direction. None of it is undoing the damage which was done to LASPO and the contemporaneous changes to resources for criminal legal aid at that time. And I think that there is a rationing and dysfunction had become built into the system. We see that in the backlog. We lawyers and the justice system have been squeezed over the past few years. I'm not making part of a political point here, but you can see that. I think it's an objective fact. It's represented by things like industrial action, which none of us want to see, but that is a symptom of that dysfunction, I think. Why is that relevant today? I think because there's a deprofessionalisation, which is a rather clumsy word here. I totally agree with what Thomas said, that you don't always need lawyers, but sometimes you do. And the proliferation of litigants in person, unqualified or untrained advice in that way. And I'm not being snobbish here because MPs are guilty of this for everyone. We've taken part in some of the exercises in my surgery to see how much of it was actually legal advice. At least 1 in 4 of the people who come to see me now really need legal advice, and we are struggling to find them that advice. When I started on the board of the Hampshire Law Centre, it was 30 years or more ago, I guess we all thought there would be a law centre network across the country. Every town, every city would have its own network. If anything, it's shrunk over that time. None of this was ever perfect. There have always been holes in the system, and as Laura says, pro bono has filled some of those holes. The system of access and eligibility was like a Swiss cheese. but it's now more holes than cheese, you feel, and it's quite difficult to maintain that say that we are achieving what we would all wish to achieve, I think, and we shouldn't ignore that. And therefore, people are not aware of the role of lawyers so much. Lawyers have never been popular, I think that's right, except possibly their own clients, and even then, that is not always the case. But I do think there's less respect now. I do think there's more vilification now than there used to be. Some of that is at the door of the press, some of that is at the door of social media or politicians. I won't say any more about that, except to say a positive thing. I think we were quite happy with, I'm not saying that because she's here, with the new Attorney General, and quite happy with the new Lord Chancellor. As it was a lawyer, perhaps more than a politician here, but we thought things had got a little bit better. And that's not just because the Lord Chancellor is a former Shepherd Bush Chancellor. That's probably our most distinguished thing on his CV. But
every time.
Every chairing the All-Party Group and everyone. Yeah. Lefty lawyers, yes, but before lefty lawyers, we had fat cap lawyers.
Yes, that's
that
true.
way.
That's
So
true.
it's gone on in that way. But I do believe that we're in a different climate now. One of the things, I'll be very brief on this. I think diversity is important. We're all waiting breath for the First Lady Chief Justice. But it needs to go a lot further than that. It needs to go through the judiciary and through the public. So we are on a learning curve in Parliament here and in politics, but this is not tokenism. This is about the public being reflected and the people who are judging them, advising them, everything else in that way. And I think that will make it different. Finally, I'll mention it's and I'm talking about yesterday, SLAPs, because I think SLAPs is quite a good illustration of where we are. That the Alex Chalk is going to introduce, or rather in the House of Lords, going to introduce some very welcome legislative changes. Yeah. Although they won't be comprehensive, they won't necessarily deal with some of those key freedom of speech issues, or the wider issue of oppressive conduct in litigation. And I would cite, for example, what Benson was trying to do in relation to oppressive behaviour by the media rather than to the media in that way. A lot of it is related to costs, a lot of it is in relation to the inequality of arms we were talking about. It's not easy to resolve. Lawyers have to be paid, and we don't want to tie the hands of lawyers. And doing it, what I'm talking about, doing it through regulation has its own problem. But doing it through clear legislation and clear direction from the senior judiciary, I think is long overdue in that way. And we will then, that will help to restore some of the reputation that's become tarnished. Some, not all in that way. There's a lot we can do, but I'm afraid there is a lot there to be done. Yes.
So thank you very much to every one of the speakers. I've been given a few pre-submitted questions, but I don't really want it to be all just me. So what I thought I might do is I will probably put a couple, but I will invite members of the audience to come in quite quickly, and maybe, you know, I'll do one, then come from the audience, then, you know, I've got something for everybody, but actually I think it's much more interesting what you, and also people, it's very question would like to ask rather than hearing what an MP is asking. Can I just kick off with one question, Lord Thompson? You were talking about, I suppose it was an access to justice point. You made a very, you know, very sensible point that tribunals, for example, which were deliberately set up to be informal so that you could vindicate your rights without having a lawyer, are often not that. And you do get, you know, people walking into, say, an employment tribunal represented by a solicitor and a barrister, and boxes of files being brought in, and it's to all intents and purposes indistinguishable from. I just wanted to ask about three things, really. How you think we sort of improve access to justice in those areas of the law where people might well come up against, you know, for example, a family dispute, and they're probably much more likely to be involved in a divorce than they are really a serious crime in their life. And secondly, whether you think we make sufficient use of alternative dispute resolution, particularly in those environments meant to be less formal. And thirdly, where you think AI is going to take the profession and
what I do think it's important is to recall the lawyers genius at complicating the simple. The biggest example of this was workmen's compensation in the 19th century. It was given to the county courts as when they first came into existence in 1846. The volume of work before them was enormous, and everyone thought these are wonderful. We'll give it we'll give workmen's compensation. They realised the horror of that mistake later. And I do think that the profession and the judiciary is to blame for the mess we made of it. To put it bluntly, we made it too complicated and we got away from the very simple idea of that. So I think one is we ought to think again about simplifying things. And I think that next takes me to answer your first of your direct questions. Again, I think there are two considerations. One, our adversarial system cannot cope with litigants in person who are adversaries about something that's largely emotional. And so you have to look for an alternative if you're not going to pay for lawyers. Secondly, I think it is important that the mechanism you put in place has decisive effect. And I think that what I've been quite impressed with, there was a conference organised last month or the month before in April about problem solving courts and the success of the system of family media, of these courts dealing with, on the basis of the individuals, the problems, particularly those relating to issues that are important to the individuals, but maybe not as important to greater scheme of things, as to access and contact and timings and that sort. And I think you need to de-lawyer that if you can conceivably do so, because it's unrealistic to think we can afford to do that any longer. So I think mediation has its problems in that it's not well designed for two people who are antagonistic for reasons that doesn't relate to the original. So something like a problem solving court may be the better answer to that particular question. And as to ADR, I'm going to tie that to AI so I can keep so you get two advice. One, and that is, I think that we have got to look forward in AI so that it doesn't become an instrument for creating a two-class legal system. And therein lies a real danger. And I think it's evident from Professor Susskind's most recent edition of his book on future lawyers. And I do think, therefore, we do need to put money into looking at AI that can help in advising. I remember doing a hackathon now 6 years ago as to trying to devise a program. But of course, things have transformed themselves. And one knows that ChatGPT is in the top few percent and at speed exceeds any human being. And so I think there must be potential there. And I think we ought to bring that to bear, not only to advising, but also as an aid to decision making in cases you can strip out the bureaucracy of court and add a system that's automated that leaves to the human the decision.
Brilliant. Right, I'm going to take a question from. We have one, do we?
On the chat, is that what you're about to say?
Yes, from the chat. Yes.
Nikita.
Nikita.
Question: how can judges judge if key evidence is not disclosed to the court? I presume with the knowledge of lawyers.
So I think this probably goes to what Nick was talking. Nick or Thomas really, but Nick was talking about the duties to the court, and I suppose you always get the overzealous practitioner who is very reluctant to disclose the email that comes out later that's not helpful to their case.
Yes, I wonder whether it's a question which has got half an eye on the post office.
I think what
Position.
the post office question was in my pack, and I think if I just dovetail it with what had been submitted in advance, lawyers who fail to balance their ethical duties with the commercial interests of their client, and that's sort of just a very high profile, particularly vicious example.
Yeah. Well, perhaps can I perhaps try and answer the two together to some extent. And I think particularly in an audience of lawyers, you will understand why I'm a little cautious, and I'm going to be quite careful about some of the things I say because there is an ongoing inquiry.
Yeah.
But on the other hand, it is so important that I do not want to duck these issues, and I hope I have something of substance to say. I mean, I think anybody who has followed the post office scandal, and it is a scandal, will realise that it is taken as a whole one of the most serious miscarriages of justice in recent years. So it is absolutely right and proper that there is a review going on, and I think we all welcome that review. The review is going to look at, amongst all the other things it looks at, the role of lawyers. And we already know some things about the role of some lawyers in this unhappy saga. One of them is a barrister, Simon Clark, employed at the time by a firm of solicitors, Cartwright King, who wrote two really important advices in July and August 2013, dealing with the Post Office's failure to disclose adverse material. You can read those advices online, and they make a very good read. And I think many people would find it extraordinary that despite those advices, there were a series of prosecutions thereafter, which did not apparently take heed of that advice, and which led to further miscarriages of justice. So when the inquiry reports, I fully expect there to be criticism of some of the lawyers involved, but what it will be, I don't know, and I don't want to go any further than that. But I did just want to come back to the wording of the question, because the question said, we've seen in the Post Office scandal lawyers who failed to balance their ethical duties with the commercial interests of their clients. And I'm afraid I've got a real problem with that question, because there is no balance to be struck. Lawyers have ethical duties which they must comply with, whether or not that suits the client's commercial interest. And one wonders whether, when say any more than that, whether the problem may have been in some part that it wasn't sufficiently appreciated, that those ethical duties. And that's why I took you to the right at the beginning. There are no ifs and buts. You must be independent as long as it's in the client's best commercial interest. It will be interesting to see what comes out of it. I think one thing that will come out of it is a focus on the ability of any entity, but here the Post Office, to prosecute in cases where it is also the victim or perceives itself to be the victim. The Post Office thought that it was the victim, wrongly, that it was the victim of dishonest postmasters and postmistresses. If you think you're the victim of something, how easy is it to discharge your proper duties as a prosecutor? I think it's very difficult. You're almost inherently. So I hope we will look very, very carefully at whether or not it is ever appropriate to give private prosecution findings in circumstances where the prosecutor might believe itself to be the victim.
Excellent point. I've never thought of it in that way. Actually, that's really interesting. Right. Is there any other questions from the floor?
There is one more. The discussion has understandably focused on trust in the legal profession and system. It seems that many challenges relate to overcomplicating and increasingly poor quality of much legislation, regulation, and the risk of overcomplicating law and access to justice. In fact, thereby denying access. Lord Thomas rightly touched on this, and others comment.
Yeah, I will get any longer.
No, I don't mind at all. My office has an official mission statement, which is providing law at the heart of government. I have an unofficial mission statement, which I feel just as passionately about, which is please don't make legislation that isn't necessary. And I really do feel very strongly that Lord Thomas was bang on the money when he said that we have a tendency to overcomplicate things as lawyers, but that politicians possibly have a tendency to want a virtue signal by means of legislation, which is not something that is always helpful. In fact, it's very rarely helpful in my experience. Of course, lawyers have always been accused of overcomplicating things. I was listening to everybody on the panel with whom I wholeheartedly agree, or almost entirely. And I was thinking, yes, but Charles Dickens. And I thought, well, actually, you know, what we're saying about Twitter now would have been said about weekly publications then. And we have always had a reputation for wanting to overcomplicate things. But I was also reminded, listening to Lord Thomas, that really great lawyers, and I'm afraid, without wishing to suck up to him, I put him in very firmly in this category, are able to distill what is or what seems complicated into very, very simple statements, which is what he's done for us this afternoon. So yes, I do think it is part of my role to try and help my clients, the government, to legislate properly and where necessary, and in a way that I hope makes the law comprehensible. I'm going to introduce one more idea to this conversation, which is relevant, I think, to the access point, which is that law has to be understood by those it serves. And legal education is a key part of the discussion we're having and the actual real operation of the rule of law. And unless the law we make is clear and really serves the people we're here to serve, then it doesn't work.
And how would you improve that?
Well, I think legislating where necessary, being clear as lawyers about what we think things are there to do. Much of what we do is complex. Of course it is. Regulation can have to be extremely complex and deal with many, you know, I don't want to be flip about it. There is no doubt that some of the work that lawyers do has to tie off every you know, sort of option and think through possibilities and try and close off loopholes. And there's no doubt that there is a place for that. And that's something that Andy, who, to be fair to him, because he's been very nice to me this afternoon, has campaigned very hard on SLAPS for a long time. He wants to do the right thing. He wants to close down the loopholes. He's right to say there is a role for primary legislation there. Let's make the point in primary legislation. But let's also remember that the way of dealing with SLAPS is not just going to be legislative. Courts issue claims. They make normally a very good value judgment and they assess the whole issue when they're issuing a claim. And yes, there will be a legislative point there, but there will also be many other ways that we as lawyers and those in the court service can deal with the problem of SLAPS that will not necessarily be legislative. So I've answered with an example, which is something that again lawyers tend to do, I find.
Andy, a question for you. I mean, I'm going to slightly distill the one in front of it. You may have seen it. It's about ethical behaviour, and I think the question is, lawyers, whether they're solicitors or barristers, have to adhere to a code of conduct. And there is sort of, you know, there are principles of public life, principles. But I think the question is, you know, should parliamentarians and ministers be leading that kind of ethical, demonstrating and show leadership on that ethical area, or are they behaving undermines it?
Yeah, I had a version of that question which ended, should we all look to Parliament as a role model for ethical behaviour? Well, I think the action from the panel, let alone the audience or the general public, probably answer that. But we should. Can I just make one quick comment? What a bit Victoria, I don't disagree. There's nothing new, and I will answer the question. There's nothing new about government legislating to prove a point, to campaigns, You can't have a year without a criminal justice bill, can you? Because you want to meet up on crime and the cause of crime and all that thing. I do think that's what works. I do think a lot of legislation at the moment is performative, for want of a better word. I hope we've seen the back of the Bill of Rights, for example. But some of the immigration, some of the public order legislation that's going through is about political signalling, I think. But yet it does have an effect, and often an effect which may be intended or unattended, but certainly hasn't been thought through in that way. And I think we're in a poor phase. We're not in a vintage legislative phase, if I can put it that way, and which links up with the ethical point, if I may. I've got a draft of a bill that's coming and published on Monday here, Economic Activity of Public Bodies Overseas Matters Bill, which the long title says, make provision to prevent public bodies from being influenced by political or moral disapproval of foreign states. Well, again, if we're going to start letting people on their morality in that way, I think we will lose that audience pretty quickly. But nonetheless, I think we should take lessons from what Nick has said about the standards that the legal profession adheres to or is told to adhere to. Certainly on a personal level, we should do that. On a political level, it might be slightly more fluid. What's the equivalent of our duty to the court? Is it duty to Parliament? Is it our duty to our constituents in that way? But we work in a similarly adversarial system in which, yes, we advance our own arguments, we advance our own case, we expect somebody else to put the other case in that way. So it's not that dissimilar, and undoubtedly, whether it's just things are more evident, whether things are more open, whether the bad behaviour that we've seen in Parliament always happen and we're just hearing more about it, I don't know, but we have to put our house in order. That's absolutely certain, because we're asking people to trust us with their most important things of their life. We have to show that we're worthy people to trust them.
I think it's absolutely true to say that there is a higher standard of ethical behaviour that's required in the administration of the law than there is in the making of the law. And there isn't an overriding duty of Parliament, which perhaps there should be. Just one illustration of that is that in the adversarial system of Parliament, it is very, very rare to see a politician, particularly one of the two main parties, concede in a fair way that the other side has made a good point or something. Whereas it might be in the public interest actually for that concession to be made as the debate continues. And I think actually part of that may also have to do with the fact that it's televised. People are looking at their speech and think that they will then show to the people who they represent or the interest group that they're speaking for, that they say the other side is so stupid and they've done everything wrong. And actually a fairer analysis, which the best parliamentarians are perfectly capable of this, that they made a very good point about this, but they're a bit weak here in this part. And we never do that. And the best barristers actually do that, but then they are sort of, you know, because they'll often concede where their case has got a few issues, but then they will move over.
I think the committee structure is different. I genuinely do. And bills can be improved during the process through both houses.
I agree, actually, I agree with that, but it doesn't, people are barely aware of it. Anyway, sorry, it's not in my chat. Sorry. But I have one of them, so I'm going to, are there any more coming in through the chat? And do just send one in if you'd like to ask.
Oh, we do have.
Well, how about we do, well, how long we've got, okay, right. One, you choose, Nikki, to the best one that you can find. Then I'll ask Lubna Hers or whatever everybody to answer something. And then Lord Hunt, I think you should just, you know, either a question or a comment on mute. I don't know, I know I'm putting you on the spot, but I think it's
Is public legal education the route to reduce the increased ethical focus, given the press and public do not understand the existing enormous duties we have, leading to an appetite for action with the AG, which the AG has just cautioned against?
public legal education.
Yeah.
It sounds like it's a question for the AD, but actually I don't want to don't say.
I love it.
Sorry, for me, this is a bit of a long question.
Right, is public legal education the route to reduce the increased ethical focus, given the press and public do not understand the existing onerous duties we have, leading to an appetite for action, which the AG has just cautioned against?
So, I mean, I think absolutely we need to educate the public. There's no doubt about that at all. And I think the comment made is very fairly made. I think the public don't actually understand that lawyers have got ethical standards that they need to comply with. How do we get that out? We do it by, I mean, certainly I'm doing it. I speak publicly, media, radio, articles, really trying to emphasise that lawyers are held to very, very high standards. We need the public to understand that. Sometimes they don't get that. The media doesn't get that. And it's really important that we make sure we put that out there and educate them, because we've all been talking about the high standards that we are all held to, and the public don't always understand that. It's important that they do. So we should do whatever we can, I think, in terms of public legal education. Absolutely. I don't know if anybody else wants to come in.
No, I very strongly agree. That's slightly why I threw it out there. I think we are here to serve the public. The standards that we adhere to are very much part of our constitution, and the way that the pillars of the constitution balance each other. And it's really critical that we continue to explain that to people. And that's why I do think we have a role as, if you like, leaders of the profession, to talk very powerfully about the good work that is done by lawyers. I think it's easy to criticise, and I think we're all it's easy to fall into a trap to say we haven't got enough money, we haven't got enough this, we haven't got enough that. But it is really important that we talk about the good work that is done by our extraordinary legal sector and our fantastically independent judiciary every day.
Yeah, one of the things that we're working on at the Law Society is changing how we talk about the rule of law and changing how we talk about justice and the justice system, because we really need the public to understand what we mean by those concepts and to understand why our justice system is so important, to understand that actually the work that lawyers do, it pretty much underpins everything that goes on in society. There would be chaos if we didn't have lawyers. They are there to make sure that things are running smoothly, they set contracts, they give advice. And we need the public to understand what value they bring, what does the rule of law mean, what does it mean to them, that, until they go and see a lawyer. It's coming back, I know you've talked very much, Lord Thomas, about not going to see a lawyer, but actually until members of the public do go and see a lawyer, that's when they appreciate what the value of seeing a lawyer is. We could have a big discussion about some of the remarks that Lord Thomas made, because I think I'd have quite a lot to say about some of the, I think you had some great thoughts, but equally some pushback on some of the ideas that you had in terms of not having legal advice available, where in many situations it's actually quite critical that parties do have it. But I think that's another session and another conversation which could go on for a lot.
I've enjoyed this conversation so much, really sincerely. I want to thank everybody who's given up their time. It's been one of the most interesting wider conversations about the profession and Parliament that I've had definitely since I was elected. Lord Hunt, I'd like to hand over to you for the final word.
Well, Laura, great thing about lawyers is that our system of justice is admired. The impartiality of judges is admired right across the board. Following my president, when I was admitted to the role in 1968, very great man, Lord Day, he personally saw every solicitor who was admitted. And as he shook my hand, he said, I'll never forget what he said. He said, you are now committed to the highest possible professional ethical standards. So when alleged sleaze grew up 30 years ago, I went straight on the advice of James McCurry with my corpus department to see a senior judge whom I called Nelly. And I said, please, would you investigate? And he not only investigated, but he then, with his committee, which we set up, came forward with the 7 principles of conduct in public life. So those statements are now underpinning everything that we subscribe to. And that's, I think, probably the lesson. If we all follow those known principles, then we won't go far wrong.
Thank you so much, and thank you to everybody who participated in the meeting today. Thank you.